Hi everyone, and thank you first of all for watching our video in relation to the independent children's lawyer, which, as you may appreciate, is an extremely important topic. Thanks for subscribing. Hopefully you've subscribed to our YouTube channel. If you haven't already, just click the red button, the red subscribe button, which you'll see there. By doing that, that will ensure that you keep up to date with all of the videos that we upload to the Family Law Australia YouTube channel. First of all, a bit about me. My name's Shaya Lewis-Dermody and I am a qualified independent children's lawyer. I'm also the principal solicitor of a law firm called the Family Law Project. So what is the definition of an independent children's lawyer, or an ICL? Well, the Family Law Act of 1975 sets out the definition of an independent children's lawyer. And an ICL for a child means a lawyer who represents the best interests in court proceedings under the appointment made by a court. So the ICL is to represent the child's interest rather than acting directly upon the child's instructions. So who are independent children's lawyers? Well, first of all, we're specialist family lawyers. In order to have completed the national training, the national ICL training, we had to have first had at least 5 years practice exclusively in the family law jurisdiction. Most ICLs before doing the training have more than 5 years. I myself completed the training in 2008 and I've been practicing as a family lawyer for about 13 years now. So the court actually has guidance as to when an ICL should be appointed, and those guidelines largely come from some case law. I won't bore you with the details, but there was a case called Reed K which sets out specifically circumstances in which an ICL should be considered to be appointed by the court. And it's very clear that the first example given in that matter was where there have been allegations of child abuse, whether that abuse be physical, sexual or psychological. The second guideline is where there's an apparent intractable conflict between the parties or the parents, as it may be, cases where the child is apparently alienated from both one or both of the parents, and whether there's issues of cultural or religious differences that may affect the child. Other circumstances where an ICL might be appointed as where the conduct of one or both parents is so antisocial that it's impinging on the child's welfare, if there's significant concerns around medical, psychiatric or psychological illnesses in relation to either a party or a child. So for example, I've been appointed as an ICL previously in a matter where the parties were unable to agree on the medical procedure for a child who unfortunately had a condition which would see him dying within a number of years. Further examples may be, for instance, where neither of the parents seems suitable to act as a custodian for the child. In those circumstances, it's not uncommon actually for welfare to be invited to intervene under Section 91B of the Act. Another example or guidelines is where the child's of mature years, so a child who's a little bit older and is able to express their views. And sometimes, not always, I'll get into that a bit later, but sometimes the ICL is asked to ascertain the child's views. Another one of the guidelines is where it's proposed that the child will be removed from the jurisdiction being Australia, particularly so when we're talking about one of the parents wanting to remove the child to a country that's not a signatory to the Hague Convention, because of course there's huge implications there. But also we're talking relocation matters, so it might even be, for example, one parent's wanting to move to a country town out of the city, or even to a lesser extreme, moving from one side of the city to the other, which in cities such as Sydney can create huge difficulties. And lastly, one of the guidelines that we do use, and we do see an ICL being appointed, is where there's cases of potential siblings being separated. And a further example, which is an example we're seeing a lot more of recently, is where both parties or both parents to the proceedings are self-represented. So that might be another example of where an ICL is appointed, and I've got a few of those matters at the moment which can present all types of issues and difficulties where parties are not having that input of specific family law advice. And that list I've just run through, that's not exhaustive, so there are other examples of where an ICL might be appointed by a judicial officer. So in terms of the general nature of the role, that's set out to a certain extent by Section 68L of the Family Law Act, which is the section of the Act which enables the ICL to be appointed. And what that section of the Act says is that the ICL must form an independent view based on the evidence available to them of what is in the best interest of the child. And we're also to act in relation to the proceedings in what we think is in the best interest of the child. So what we're not is that we're not the child's legal representative, in that we're not bound to act on the instructions of the child. And there's a bit of a misconception out there, and a bit of a myth, I guess, around children of the age of 12 and above being able to directly instruct their lawyer or their ICL, and that's actually incorrect. So regardless of the age of the child, and I act for children over the age of 12, we're not bound to act upon those instructions, and often, as you can imagine, the instructions of the child are not actually in their best interest. And the section of the Act also sets out specifically what our duties are as an ICL, and we must of course act impartially when we deal with the parties, and I think that's particularly so when one or both of the parties are self-represented. There's nothing worse than being self-represented and seeing the ICL having a friendly chat to one of the other barristers or solicitors and really feeling disadvantaged in that respect. So it's very important as an ICL to act impartially. And we also must ensure that the views of the child are put to the court. That's even if we disagree with those views, we need to at least relay them to the judicial officer. And if there's documents that have been used in the proceedings, such as family reports or memos from family consultants, psych reports, there might be subpoena material, for example, then one of our roles as an ICL is to analyse that information and ensure that all of those issues or issues that come from those documents are drawn to the court's attention. One of the other roles that we have is to ensure that we minimise the trauma to the child associated with the proceedings, which of course is an extremely difficult role, and I'm not sure, I suspect many ICLs aren't very successful in doing that. It's really, to a certain extent, falls outside of our limitations. One of the final roles that we have is to try and facilitate an agreed resolution of all matters between the parties, and again that can be particularly difficult dependent on the solicitors acting and also whether one or both of the parents is self-represented. One of the difficulties that we do have as ICLs is I guess the lack of the uniform approach across Australia. So for example, I've worked as an ICL in New South Wales. I also currently work as an ICL in South Australia, and I've also practiced in Western Australia, and certainly the role and the expectations of ICLs in each of the states and all of the states is quite different. And for that reason, in 2007, the National Legal Aid Body, who's in charge of appointing ICLs, came up with a set of guidelines in an attempt to create a more uniform and national approach. So the national guidelines of 07 were endorsed at the time by the Family Court and the Federal Magistrates Court, as it was then known. It's now the Federal Circuit Court, and it's really seen as an extension of Section 68L, which I went through above, that sets out those guidelines. So what those 07 guidelines say is that it's in the best interest of the child for the ICL to enable the child to be involved in the decision making as best as possible, for the ICL to be truly independent, which is again is a repetition of Section 68L of the Act. It says that the ICL should work together with the family consultant and the experts. So, for example, one of my roles as an ICL is I'm often on the phone to family consultants and family report writers, both during their assessment process and once they've released their reports, just to have a discussion about the family and see if there's any perhaps gaps in their reports or any further information that I can obtain from them that will be useful to both the parties and the court. The guidelines go on to say that the child has a right to establish a professional relationship with the ICL, and I see the Sydney and New South Wales ICLs are very good at doing that, and it's not uncommon, for example, for them to be given or giving the children their direct phone number, which I think is wonderful. The ICLs also to explain their role, the limitations in the court process to the children. So one of the first things that I do if I meet with a child is there's a fantastic, again, a YouTube video from the New South Wales Legal Aid Commission, which is great for children because it really explains the ICL role to children. So we'll often sit down and watch that together, and then following that we'll then have a discussion just to see if there's any further questions that they've got about the court process generally. So another role is that the ICLs to ensure that they tell the child how the child can make their views known. Having said that, it's not our role to conduct disclosure interviews or to become a witness, and certainly not to conduct therapy or counselling. That's simply not within our role or our profession. And as I mentioned just before, one of our roles is to ensure that the child's views is put to the court, even if in making the submissions, our submissions are contrary to what the child's views actually are. One of the big questions that we do get as ICLs is whether or not we meet with the children, and particularly so, and I see this a lot on social media, is a lot of frustration that parents have due to ICLs not meeting with their children. So what the guidelines, the national guidelines say is that it is expected that the ICL will meet with the child, but there are some exceptions to that. One of the exceptions is that if the child's not of school age. So, for example, if I've got a child that I've been appointed to act for and they're under 5, really there's not a huge amount of benefit in me meeting with that child because our communication will be limited. If there's exceptional circumstances, so what we're talking about here is if there's been any ongoing investigations by police or welfare, or if there's any system abuse, so you're talking about children who've been constantly seeing different professionals, and unfortunately, due to the nature of the appointment of ICLs, which is often in circumstances where these allegations have been made or there have been current welfare and police investigations, I personally, in those circumstances, choose not to meet with children unless it's purely for the role to explain to them more about the court process, because I don't want them to be subject to system abuse, and I do have serious concerns about that. One of the other reasons why we might not meet with children is due to geographical distances. So, for example, if I'm in Adelaide and I've been appointed to act for children in Ceduna, which I am, that's an incredible distance to travel to meet with a child, and unfortunately the legal aid budget doesn't extend to pay for my travel to those communities. Likewise, when I practiced as an ICL in New South Wales, it's an incredibly big state, and it's not uncommon to be appointed to act for children, for example, in Dubbo. So despite the national guidelines of 2007, my experience is that the role of the ICL is very much state by state dependent. So to give you an example, when I practiced in Sydney, in the Sydney office of the Legal Aid Commission, they had a specific room set up where we would meet with children, and it was very much a child-friendly room. Whereas practicing as an ICL for Legal Aid, when I worked for Legal Aid in Adelaide, the majority of ICLs at that time were very much opposed to meeting with the children. So we do have these national guidelines, but it's still, I can still see division between the states, and I can also see division between particular practitioners regardless of where that practitioner is based. So this has just been a really quick summary about the role of the ICL, and just to finish on a very important point, which is the role of the ICL, in my view, is a privilege, and it really should be taken with respect to the court, to the families involved, and most importantly to the child or the children. So just finally, thank you for your time in listening to this brief recording. Please do head to our website. There's lots of interesting articles there. You can also subscribe to our free newsletter, which has lots of information about family law, relevant. We promise no boring bits. You can also contact us there through our website for a free meeting with one of our specialist family lawyers. So I hope you get in touch, and thanks again, and please remember to subscribe to our YouTube channel.